Good evening. Welcome to The Advocates. Each week at this time, we look at an important public issue in terms of a practical choice. Tonight's issue deals with a question of protecting the constitutional rights of the accused while still protecting the prosecuting rights of the society. Specifically, the question is this: should courts be able to admit evidence that police have seized illegally?
My next witness is Congressman Mike McKevitt from Denver, Colorado.
Congressman, welcome to the show.
Thank you, sir.
Congressman McKevitt is a member of the House Judiciary Committee and a former district attorney for 4 years in Denver. Congressman, is the Benson bill a sensible approach to the problem addressed by the exclusionary rule?
I think it's a very sensible approach, and I think so for this reason. It'll give the trial court the power to determine or to have discretion between serious violations of illegal searches and those which are technical violations, which oftentimes the officer didn't have the 20/20 hindsight to determine it would be an illegal search in the first place.
Under the Benson bill, if they find a substantial violation, they're supposed to exclude the evidence. Isn't that correct?
That's correct.
It's only the technical violations where the evidence is allowed in.
As I say, the non-serious type violation, the court would have the discretion, would be in the discretion of the trial judge to do that.
Does the bill provide any remedies for people whose rights are violated by illegal searches and seizures?
I think this is one of the strong parts of the bill, counsel, is the fact that under this system now, a party who feels he is wrong will be able to bring a suit against the governmental agency. It would be the United States government in this case. And if he does have a valid claim, he'll have a much better chance of collecting against the government than if he would if he were to sue against an individual police officer.
Do you believe then that it's a better remedy than the present one, which he has only against the officer?
I think so, for several reasons, principally because of the fact that oftentimes an officer is judgment-proof, and oftentimes he will draw the sympathy of a jury as well, and the jury would be inclined to rule against the plaintiff in that action.
How do you hook this up to the question of whether the court should admit the evidence? What's his right to recover have to do with it?
There's two provisions of the Benson bill. The hookup is that you get the deterrent out of this civil action that the proponents of the exclusionary rule claim can only be derived from the exclusionary rule.
All right.
What was your experience with the exclusionary rule as a district attorney for 4 years?
I think my principal experience as a district attorney was that there was a lot of cases where they were clearly guilty and they were allowed to go free.
Can you give us some examples?
Well, I think one of the most classic examples, some may disagree, but it's just particularly on searches of narcotics cases where they came in, the officer would have to act quickly under the circumstances to determine, because they could clear the area, clear it from a raid standpoint, whether evidence was thrown out later. Gambling is another case where it comes into play. Narcotics, gambling, and use of weapons are the three big violations we saw.
Mr. Ware, it's your turn.
Congressman McKevitt, you've had an opportunity to see an awful lot of law enforcement, haven't you? Good and bad.
Yes.
When you see a good case, the case holds up in court. When you see a bad case, it gets pitched out. Is that correct?
Well, it's sort of an oversimplification, but you hope that...
well, if it's a good case, you don't have to worry about the exclusionary rule, do you?
No, I think you're, counsel, I think you're oversimplifying that issue there, because the problem you run into, you oftentimes, I think, have a good case in substance, and you may have a minor technical violation.
What do you consider a minor technical violation?
Well, you can give any number of examples, but I'm talking about small, insignificant situations or small violations, which really doesn't go to the substance of it, and yet bars it out of there because of the strictness of the exclusionary rule as a result of Mapp versus Ohio in '61, the Supreme Court case.
The illegal search and seizure by a police officer does violate the Constitution, doesn't it?
Under the strict interpretation given by the Supreme Court in 1961 and 1914, yes.
And law enforcement officers are there to abide by the Constitution and enforce the Constitution.
That's correct.
Now, you and your office as district attorney, did you ever have an opportunity to see the exclusionary rule sustained where they threw evidence out because of a bad arrest?
You mean on technical violations?
On technical violations, on bad arrest, no probable cause.
You mean whether it was actually barred and we lost our case as a result of it?
Certainly.
Yes, many times.
Did you bring any action against a police officer?
Well, what you try and do there, for example, I set up
I asked you a question, Mr.
I want to answer your question,
Did you
counsel.
bring any action against a police officer?
I want to answer your question.
Go ahead and answer.
The action I brought was the nature of trying to educate the officer even more. But the problem you have here is that you can't expect the officer to have 20/20 hindsight and guess ahead what the rulings of the trial court will be in the future.
Now, normally, when you saw the exclusionary rule come into effect, it was a deliberate action on the part of the officer to go someplace to arrest someone and stop him and search him. Isn't that correct?
You mean a deliberate action by him?
Certainly, it's a deliberate stop, it's a deliberate search, and if they had properly prepared themselves before that, they could have obtained the necessary documents to make it an effective arrest, couldn't they?
That's a beautiful theory, except the fact is an officer's under pressure at all times, and particularly under certain circumstances, and you can't expect him to have
Well, you
perfect
mentioned
judgment.
gambling, you mentioned narcotics. They don't stop gambling in 1 day, in 1 minute, in 1 hour, do they?
Oftentimes, narcotics raids took place in a matter of 30 minutes.
Okay, so but that doesn't mean they're going to stop using narcotics in 30 minutes, does it?
I don't get your point.
Well, can't they come back and get the proper warrant, come back and make the arrest effective with the warrant?
The evidence could be confiscated by that time.
It could be, but it could not be.
Oftentimes they stumble into the situation too. This was the classic case we had oftentimes, where they would discover it, the neighbor would call, they go into a situation, all of a sudden there they are, and they thought there was a legal search, and they find out later the court determines that it wasn't.
Let me ask you a little bit something else on this. If the exclusionary rule were to be abolished, this would give the law enforcement authorities the power to make their own determination, their own judgments on the street as to what they should do. Isn't that correct?
I'm not asking that it be excluded altogether. I'm asking the fact that you have a discrimination between the serious offense and the more technical or the less serious offense, and give that discretion to the
Who's
trial
to make
court.
this determination?
The trial judge.
Trial judges to have the ability to try and discern what's some type of difficult and serious offense as opposed to a minor offense?
We give this trial judge many discretions already, and this would be one more for him.
So this would just be one more thing for the trial judge to try to find out?
Yes.
And your ability to prosecute cases and try them up in Colorado when you were prosecuting attorney, did you have an opportunity to see judges from different areas and different jurisdictions?
Yes.
This is the
Did
last
you
question.
see them deviate from one area to another in their sentencing?
You see a great deal of variance. Judges are humans. They put their pants on
So
one
there's
leg
a
at time.
good possibility they're going to vary again.
Congressman, we have some judges on the show tonight. We're going to test that theory. Thanks for being on the Advocates.